everyone. Happy Wednesday. So we've spent a lot of time talking about warnings for the Department of Labor for various other employment agencies and claims, including lawsuits. What we've never really touched up on is if you already have a Department of Labor complaint or claim, what alternatives do you have and where do you go from there? And of course, there's the what you assume would be the next steps, right? You have to go through the entire audit. There's probably a very grueling process because they're asking for a lot of information, a lot of documents. That's what we've always talked about. But in addition to that, what happens next? And what are the next steps? What are the next alternatives? So from our perspective, legally, we've had a few situations where the responses have come in and they have been absolutely incorrect and inappropriate based on the documents that we have actually provided. And so that led us to have to apply for a administrative law judge hearing. And that could be a very, very long process. And you could wait a very, very long time for it, sometimes years. And so what are the alternatives from there? Because let's say the administrative law judge also doesn't review the proper documents, doesn't assess them in the correct way. What recourse do you have and what do you do next? Typically from there are some legal alternatives, and that could be filing potentially an Article 78 or so on again. And these are very fact specific. And so it depends on what the case is. And in some matters that's not available. But in all cases, that's very long. It could take a lot of time to even get there, to even get these decisions from every level, the auditing level, the administrative law judge level, and then to take it to court afterwards could take so much time and so much frustration, not to mention the expenses spent getting there. And so this brings up, we've been recently talking about this brings up just a discussion that we had just this week with Jane, and we were talking about one of her clients in a similar situation. So Jane, could you tell us a little bit more about that?
Sure. Thanks, Irene. So, a client of mine got this notice of experience of rate charges. So basically, it's a letter that comes from DOL, and it basically states different time periods that the employee that they were actually still employed by the company were getting unemployment charged to the client. So kind of a little bit of a background. These days, people have a lot of different part-time jobs. They have different employment statuses. So when they applied for the unemployment, I believe that there's no way to specify which company you're actually filing against, I guess, right? So that kind of comes in with a lot of paperwork from DOL. So what happened is that the